What you want to know. What you need to know. Talk 1470. WNN.
The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to the South Florida Family Law Show with attorney Sean Shepard. Sit back today as attorney Shepard shares his vast family law experience. Attorney Shepard has 18 years in the area of family law. He has handled thousands of cases and hundreds of contested trials before both judge and jury. He is here every week to educate you on your rights and to answer your questions pertaining to family law. If you have a question regarding family law, call attorney Sean Shepard toll free at 888-565-1470. And now, here's attorney Sean Shepard.
Good evening, Sean Shepard here. It's Friday again, 5 o'clock. Welcome to your drive home. If you're home already, good for you. Hopefully you're all out there watching the World Cup as well. It's been a wonderful week of World Cup. Hard to work during a week when all that's happening. U.S. coming up here on Sunday playing. We all wish them the best in prevailing on Sunday. Hope you're rooting for them. We're here again for another hour of family law. As every week goes by, we discuss different issues regarding family law. And as always, we invite you to call in, regardless of what we're talking about during the hour. In particular, this hour, we'll jump around to several different aspects of family law. We invite questions from every different area of family law, regardless of what we're talking about on the air. Please feel free to call in, to tweet in, to email in. You can remain anonymous. You can call in with your name, regardless. I understand it's a delicate topic to talk about family law, but feel free to call in, tweet in, email in anonymously if you'd like to ask questions in this area. We spoke last week in depth about the equitable division of assets and debts in Florida, how the courts handle the division of debts and assets, retirement plans, real estate, other assets acquired during the marriage. I'm going to finish up a few areas with regard to those areas of the law here in Florida and move on to some other topics as well. But feel free to call in with any questions you have on any topic involving family law. I've been an attorney for 18 years. I've had the pleasure of litigating all of those 18 years from day one of my practice. I've been a litigator. I've handled hundreds of cases in that regard. I'm here to answer your questions both from a substantive standpoint with regard to the laws in the state of Florida, as well as a procedural standpoint in litigating cases, whether you have an ongoing case or whether you haven't even filed yet. If you have questions, the advice is free during this hour. Feel free to call in. I'm happy to answer your questions. We spoke last week about assets and debts and the division of those. I want to finish up a few thoughts that we didn't get to in the hour as we were pressed for time at the end. We had spoken about what assets are divisible by a judge here in Florida during the divorce. There are, of course, marital assets and there are non-marital assets. And we talked for a while about how the court looks at those. And the bookends of determining what a marital asset is, of course, the date you got married and the date you got divorced, and then everything in between is typically considered a marital asset. The valuation of those assets, as we talked about last week, can be through three different dates. The date of valuation as of the date you separated, the date of valuation as the date you filed for divorce, and the date of valuation as of the date you have your trial for a divorce. And the court will typically utilize a date that brings the most equity to the parties based upon the particular asset and based upon the particular situation. And equity, as we talked about last week, is fairness, and that's in a common thread throughout all the statutes here in Florida and all the case law in the state of Florida is bringing equity and fairness to the divorce proceedings, and judges attempt to do their best to do that by utilizing valuation dates for assets that bring the most equity to a situation. So as we talked about last week, you may have a situation where parties have been separated for a long period of time, years at a time, where they're separated and just not divorced. And the time comes where they go to get a divorce, and the valuation of an asset, depending upon the date of the valuation that's used, may be fair to one party and unfair to another. So not only should you speak to your attorney about all the assets involved in your divorce, but you should talk to your attorney about what the arguments are going to be when you go into court as to what the valuation date is for those assets, because that could change your column as far as what you're going to receive in a divorce tremendously. It could result in you losing or gaining tens of thousands of dollars in value depending on the valuation date that's used by the court. And the courts can use different valuation dates for different assets as well. So they may utilize, for one asset, a parcel of real estate, may utilize a valuation date of the date of separation. And for another asset, a 401k or an IRA, using the date of filing or the date of the divorce proceedings as the date of valuation. So there's a lot of discretion that a judge can utilize in a divorce case, and certainly you want to, from your own perspective, exploit that discretionary power the judge has to your best advantage in your case and make arguments in equity to bring as much favor to your side as possible. So keep that in mind and discuss these things with your attorney as you're preparing for a trial. Ask as many questions as you can about the process. The preparation for your trial, the preparation, as we talked about last week, for your mediation is crucial to the success you're going to have at trial. I want to talk for a few moments about processes and getting ready for trial. Oftentimes, you don't realize this till the time you get to trial, but your attorney's not prepared, or you're not prepared if you're not represented by an attorney to try a case. And I say that in the most basic of ways. When you go to a trial, it's just like any other court proceeding. It's a formal proceeding. Both parties and the attorneys involved are bound by the rules of evidence in a court proceeding. And this is no different in family court. There's no relaxed rules in family court. The rules of evidence apply, and it's a formal court proceeding. You're not well served by an attorney who's not prepared to put on your case, particularly when the other side to the case is not being cooperative from an evidentiary standpoint, and I'll explain what I mean by that. In divorce court, just like in any other court, you're bound by the rules of evidence, and with any trial, in order to put your evidence on, it needs to be in the proper form. Now, that can come in the form of testimony from parties, from third-party witnesses, and it can come in the form of documentation. And particularly pro se litigants who are not familiar with rules of evidence, and this is speaking to you, and also speaking to people who are represented by attorneys, because much attention needs to be placed upon these issues before trial so that you're prepared when you get to trial to present the case you want. Documents, in order to get them into evidence at a trial, whether they be bank records, tax records, or any other business records of any kind, typically in divorce cases, I've found in my experience in 18 years, most counsel involved in divorce proceedings will allow for the introduction of documents by stipulation. A stipulation is basically an agreement between the attorneys that neither is going to require the other to go through the task of having to authenticate documents to bring in witnesses or to prove that something is a business record to get around a hearsay objection to the documents. If you are not represented by an attorney and you're going into a trial, which is certainly ill-advised, but if you don't have the means to hire an attorney, you're pro se, you're going into a trial against a person who's represented by an attorney, be prepared that you're not going to get the courtesies of a stipulation that typically would be extended to another attorney in these cases. You're going to get a hard-fought battle from an attorney who knows what they're doing. You're going to get a situation where you attempt to bring in evidence that you don't understand how to get it into evidence. You don't understand the requirements, the technical requirements of getting around hearsay objections for properly authenticating a document. and for having the proper certifications to the extent you want to bring in a business record, a bank record, for instance. And you may walk into court and say, well, I have this piece of paper from my lender or any type of document, and attempt to introduce that into evidence and be met with several different objections, which may mean nothing to you. And particularly in a contested matter, the courts don't have much leniency for pro se litigants. You're treated just like any other attorney in any proceeding. You're required to understand what the rules of evidence are. And if you're not prepared to present your case properly, those objections are going to be sustained, and you're not going to be able to put on the evidence you thought you were going to be able to put on to make a record to prevail in your case. So again, if you're at the point where you're going to trial in a case, or going to any contested hearing for that matter, I strongly advise you to get the advice of counsel, because a competent trial attorney is going to know exactly what to do to get your case to where it needs to be, to present the evidence you need to present, to make a case to prevail for you. And if you walk in without an attorney, you're walking into an ambush. So keep those things in mind as you're preparing for your trial. Try to obtain counsel to help you with the trial process. But certainly if you cannot do that, my second recommendation to you is to actually spend an hour with an attorney and try to have a conference with an attorney, pay them for their time so they can explain to you precisely what you need to do as best you can to present your case at trial. If you don't have the money to do that either, do your best to be prepared to go into trial. If you have records that you want to introduce at trial, financial records or otherwise, make sure you have a records custodian to testify to the authenticity of the documents, and this extends to all documents you intend to use at trial, and be prepared. A lot of times if you reach out, even if you're pro se, if you've been diligent in discovery, and if you've been diligent in providing all the documents you need to provide to opposing counsel, a simple email to opposing counsel, or a letter to opposing counsel, a phone call to opposing counsel saying, look, I've provided you with these 200 pages of financial records. I intend to use these at trial. Do you have any objection to me introducing these into evidence? Typically, you're not going to get an objection at that point. However, if you do, at least perhaps you walk into court and explain to the judge that you extended an invitation for opposing counsel to agree to allow those into evidence, and he objected to that. Hyper-technically, you're allowed to object to those things, but judges in particular tend to frown on objections on technicalities when it's simply meant for the purpose of harassing you. So it's always best to ask if opposing counsel agrees to that. Try to stipulate to as much as you can. But in the event you can agree on those things, you do need to be prepared to present a case on trial with proper documents, proper authentication of documents, and to be prepared to do that. So a few things to keep in mind in that process. We spoke last week a little bit about equitable distribution of assets and debts, and I talked for a little while about the dissipation of assets by one spouse or another, or both for that matter. And I spoke about a party to a divorce case being able to bring up in front of the divorce judge that the other party has dissipated assets, that they've had a drug problem or a gambling problem, or simply had money that they kept on the side and kept from the spouse, and the other spouse didn't know about it. This intentional dissipation of assets, dissipation is just a word that means waste or depletion or destruction, even intentional destruction of marital assets. You're allowed to bring up those issues to the court in an attempt to have an equalization payment paid to you for 1/2 of the value of that dissipation. So for instance, if you're able to prove to the judge that your spouse had a gambling problem or a drug problem, or was an adulterer who spent money on somebody else and spent money that the other spouse didn't know about, you can recover that money because that's marital money. And a lot of people don't realize that, and they write off those things and say, well, that's gone and I'm never going to recapture that again. That's nonsense. You're allowed to recapture that, and the court allows you to do that. In Florida statute 61.075, subsection 1J, 1I rather, the court allows you, and the Florida legislature allows a spouse to recover intentionally dissipated or wasted or depleted marital assets going back 2 years prior to the filing of your petition. So you're not going to be able to reach back more than that. You won't be able to reach back 5 or 10 years. But the court will allow you to reach back 2 years prior to the date of filing your petition. So if you have those issues, make sure that you raise those in your pleading. Again, getting back to the file and the trial, two of the most important things you're going to do in your case. Your filing should include that allegation that you're seeking recovery of 1/2 of the amounts that have been intentionally dissipated by your spouse. Those are the things you need to include in your filing if you're pro se. If you have an attorney representing you, again, this is recognition of issues that you need to talk about with your attorney. That's something you need to talk about with your attorney. Again, I say this week to week, don't make your own decisions regarding your divorce case, and it's worth 30 seconds of your time to say, hey, attorney, I have this one issue I just want to ask you a quick question about. My spouse dissipated $10,000, last year, the year before. They had a gambling problem, a drug problem, or whatever. Anything they did without your knowledge that caused a financial detriment to your marital funds. Ask the question. That's what your attorneys are there for, to answer your questions. Don't presume that that's just lost money. You're not going to be able to recover that again. You certainly are entitled to recover that, or it's certainly entitled to ask for it at least. One thing I want to talk to you about in this hour is dealing with your attorney. And then the first week I spoke to you about handling your lawyer, talking to your lawyer, and how you should conduct yourself with your lawyer. I'm inundated with a lot of questions about people who are just not happy with the representation they have in a divorce case, and particularly in a divorce case, unlike civil litigation or business litigation, contract litigation. A divorce case is a lot more personal to the people involved, and it's that much more important that you have a good relationship with your lawyer. You need to like your lawyer from a professional standpoint and from a substantive standpoint. You need to like the way your lawyer conducts himself or herself. You need to like the way your lawyer deals with you. And your lawyer needs to respect you as a person, and needs to respect the fact that you're paying them a lot of money to represent them in this type of proceeding. If that's not happening, whether it's your first visit with the lawyer, or whether you've retained a lawyer and they were nice the first time you met them, but as months went on, you're no longer in contact with them on a regular basis because they're not returning calls or emails, or they're getting confrontational with you because the issues are being flushed out, and you two are in two different wavelengths as to what you want and what your lawyer thinks you should get. You need to recognize that that's not a healthy relationship between you and your lawyer. And if you're not pleased with the way things are going in that regard, you need to protect yourself. And the way you protect yourself is you sit down with your lawyer and say, look, when I met with you first, we talked about these issues. You were on board with what direction I wanted to take with the case. But in the past few weeks, past few months, it seems like we're on two different pages when it comes to what we're looking for. Try to correct the relationship you have with your lawyer, because if you're not on the same wavelength with your lawyer, if you're not on the same page with where you want to go with your case, it's like being in a three-legged race with somebody who's off. You're certainly not going to get to the finish line quickly, and you may not get to the finish line at all. You need to address those issues and make sure that you maintain a healthy relationship with your attorney. I encourage you, if you have a situation where you've just gone to see a lawyer, you haven't retained a lawyer yet. A lot of people, it's an aggravation. First of all, divorce is no walk in the park, and it's not something anybody wants to go through. So taking time out of your day, taking time off your job to schedule an appointment, to go meet a lawyer who's been referred to you by a friend, or you've looked on the internet, or you've found one, finding time in your calendar to take off work to go meet with a lawyer. It's aggravating, and it's time consuming, it's inconvenient. So a lot of people go and they meet with a lawyer, and they may have a decent first consultation with a lawyer, but not really happy with the lawyer, but they end up retaining the lawyer simply because they want to take another day off of work to interview 3 or 4 different lawyers. Best thing to do is to get referrals from people who've been through the process. I found that that's the best way that people feel comfortable with attorneys. And then take that information and do some internet research on the attorney you're looking to hire. Confirm that the lawyer doesn't have complaints out there on the internet. The internet, for the good and the bad, is a wonderful tool to find out everything in the world you can about anybody you want to find out about. So look on the internet, see if there's any negative things on the internet about the lawyer, and sit down with the lawyer, spend some time asking questions. But by all means, if you sit down with a lawyer and the lawyer answers your questions, and the lawyer gives you advice that you feel, is advice that you may or may not agree with, you don't necessarily have to take what the lawyer told you to be written in stone. There are, particularly in the area of family law, there's a lot of gray area in family law. There's a lot of difference of opinions on different issues in family law. And I always encourage people to get second opinions regarding matters that are of substantial consequence to you. So you may have gone to a lawyer who told you you're never going to get alimony, or you're never going to get primary time sharing with your child. And these are huge issues in a divorce case. And I've had people hire those lawyers and then come and hire me a year later, or hire different attorneys a year later who told them something entirely different, who ended up getting the relief they originally wanted, but were told during their initial visit with the first lawyer that it was impossible to get. So second opinions are important. I know it's inconvenient. I know it's aggravating. I know it's not something you want to do. But getting a second opinion, even if it comes out to confirm what the first lawyer told you, is certainly worth the time doing. A lot of attorneys, including myself, offer free consultations to people who come and visit with them for the initial consultation. I don't charge for an initial consultation with people. And anybody who calls me, I tell them, look, come and sit down with me. I'll go over your case with you, and we'll see if I can help you and how I can help you, and I'll tell you what I think I can do for you. And if you want to hire me after that, great. If you don't, that's fine too. But sit down with your lawyer. Try to find the second opinions if you disagree with the lawyer, and even if you don't disagree with the lawyer, try to find that out. Ask your attorney questions. You're going to be paying this attorney typically hundreds of dollars an hour to represent you in these proceedings. You have a right to ask questions during that meeting, and I encourage you to do that. Find out what their trial experience was like. We're going to take a short break here. I have a few messages, and we'll be back right after the break. Thanks.
Attorney Sean Shepard has been practicing family law for 18 years, and he is in good standing with the Florida Bar Association. Attorney Shepard is licensed to Florida, New York, and New Jersey. He is a trial attorney with his primary practice in the area of family law litigation. He has handled thousands of cases and hundreds of contested trials before both judge and jury. Attorney Shepard is a former judge, advocate, general court officer from the United States Navy, and therefore possesses a wealth of knowledge regarding military-specific issues to divorce and other family matters. Attorney Shepard not only handles matters from intake through trial, but he also handles all matters of post-trial and appellate work. His unique background has enabled him to develop a keen insight into all aspects of family law litigation, from beginning to end. If you or a family member are about to go through a divorce or have other pending family law problems, contact attorney Sean Shepard today at 954-632-0668. Let attorney Shepard give you sound advice and fight for your rights. Offices in Fort Lauderdale. Call him today to make an appointment. 954-632-0668. You are listening to the South Florida Family Law Show with attorney Sean Shepard, bringing you all the answers to the questions you have about family law. Join the conversation at 888-565-1470. Now, back to our show.
We're back. We're talking before the break about dealing with your lawyer and working out problems you may have with your lawyer. And one of the things that I encounter an awful lot is a breakdown in communication, complaints about lawyers who don't call their clients back, don't return emails. If you find that that's happening to you, I'll tell you this: every lawyer in the business who has any caseload at all is busy. But it's what we do for a living, and staying in contact with a client is probably the most important aspect of any case. It doesn't matter whether it's family law, civil litigation, criminal law, any aspect of the law. And a lot of clients I find are far too forgiving of lawyers when they're not in contact with their lawyer. They may say, well, I haven't heard from my lawyer in a month. I've been emailing, calling. And it's a complete lack of respect for you as a client. It's not something you should stand for. And you should expect that your lawyer is going to contact you back. Now, with that said, give your lawyer some leeway. If it's been 24 hours and your lawyer hasn't gotten back to you, be understanding in that regard. A lot of the lawyers have schedules that require their time for days at a time. But if you haven't heard from your lawyer in 48 hours, 72 hours, and it's a repeated thing over and over again, they're just not calling you back, they're not responding to your emails, you need to consider finding a different lawyer to represent you. So keep that in mind. It's certainly reasonable of you, and particularly when you're paying your lawyer to pick up the phone and call you and explain to you what's happening with your case, to expect them to call you back promptly. And you're not being unreasonable in doing that. So whatever nonsense somebody may be throwing your way that, it's been a month, but the attorney's been very busy, or they've been, out of town or whatever, you shouldn't accept that. You should demand that you be able to speak to your attorney, because that's your lifeline to your case, and it's your only way of knowing what's happening with your case. There may be times throughout your case, particularly in family law, where a month or two goes by and nothing's happening with your case. It happens oftentimes. But there's no reason for not being able to respond quickly and explain that nothing's happened with the case. And maintaining communication in that regard should be something that you should expect from your attorney. Any questions, feel free to call in at 888-565-1470. You can also watch the broadcast on WNNradio.com. You can also email in. You can tweet in questions as well in any area of family law you want to ask about. We're here to answer your questions. One of the things I harp on from week to week is making sure that what you file with a court, if you're pro se, and even if you're represented by an attorney, is accurate, and that it includes all the demands you want to make for relief in your case. And one aspect of what you file is probably the most important participation you have in any divorce case. In particular, is the filing of your financial affidavit. This is the one thing, as you may remember, in divorce cases that's absolutely required. Both parties have to file a financial affidavit with the court. You cannot agree to waive that. It has to be filed with the court. Even if you have an uncontested divorce, you both have to file a financial affidavit with the court. And this document is of particular importance from an income perspective to establishing child support, and it's crucial to a case in which you have alimony as an issue. And I've counseled hundreds of clients who are seeking alimony in cases, and the most important aspect of the case, in my opinion, is the preparation of a proper financial affidavit to set the table for your claim for alimony. And it's also a crucial part of the case for a party who's defending against a claim for alimony, because the biggest factors the court looks at in determining whether to award somebody alimony in a case are one party's financial need for that money and the other party's ability to pay that money. That's number one and number two on the list of priorities the court looks at in determining whether to award alimony to one party. Now, in filling out the financial affidavit, a lot of attorneys may simply send you a financial affidavit and say, fill this out, and whatever they get back, they file with the court. You need to sit down with your lawyer, and if you're not represented by counsel, you need to sit down with this document, and you need to read it word for word what this document says. It's a format that's used by the state of Florida. It's the same form that's used. There's one form for people who make less than $50,000 a year, and there's a longer form for people who make more than $50,000 a year. It is absolutely crucial that you fill out this document properly. And I want to give you a few points in filling this out, particularly when you have an alimony claim. And a lot of you listening out there may have an existing divorce case. You may have already filed your financial affidavit. You may have an alimony claim that's pending, or you may be defending against an alimony claim. You're not stuck with what you filed, although you can't change the fact that it's filed. You can file an amended financial affidavit. And if what you hear from me in the next few moments encourages you to do that, all the better. But it's something you should talk to your attorney about, because this document is absolutely important to whether you're going to prevail with your alimony claim or defense or fail. And what you need to keep in mind when you fill out this financial affidavit is that it needs to reflect what your standard of living was during the marriage. And a lot of people ask me the question, well, when I fill out this financial affidavit, do I put down on here what I'm actually spending right now, or do I put down here what I would normally spend on these things? Because in all candor, when you're in a divorce proceeding, oftentimes households are separated, people move out, they move into a rental property because they want to get away from each other, and that's typically what happens 9 times out of 10. The exception is when both parties continue to reside in the same house. That exception, just as a footnote, is getting a lot larger in these days when the economy is as bad as it is, and it's harder to find separate housing. I found that there's a lot of people living together, continuing to live together, even though they're separated, simply because it's impossible to move out and have 2 separate households. But oftentimes you have a situation where one party remains in the marital house, the other party moves out of the house and gets a separate rental property, and they go and they fill out their financial affidavit, and they're seeking alimony, and they put down in the financial affidavit what they're spending at this rental property. And they may have a mortgage on their house that they've been paying for years and years that's $3,000 a month, and they go out and they get a rental for $1,250, and they'll put on their financial affidavit $1,250 in rent, $300 for the electricity bill, $180 for the water bill. All the things are consistent with what their rental property is. The problem with doing that is that you're creating a record of your financial need with this financial affidavit. This financial affidavit is going to drive what your need is for alimony purposes. So you want to be able to create a record for the court that your need is not what this rental property is. Your need is what your standard of living has been for all the years you've been married. You've lived in a house that's $3,000 a month with an electricity bill that's $600 a month, a water bill that's $250. That's been your standard of living. You've taken vacations every year. You've spent $3,000 a year on vacations. All those things. You spent, $2,000 a year on clothing. You spent on grooming. All those things that you normally would have done while you were married. That's your standard of living. So when you fill out your financial affidavit, what I always encourage people to do is to put down what you're spending. So if you have a $1,250 rental property, put down that you're spending $1,250 on a rental property, but footnote that amount. And footnotes are helpful. You can also attach as many sheets to this financial affidavit as you'd like. And again, this document is crucial to your case for alimony. Attach a schedule to your financial affidavit that says, although I'm spending $1,250 in rent, here's a list of my standard of living during the marriage, and include all those things that you spent on living during the marriage, so it accurately reflects what your financial need is, your true financial need. If you took vacations during the marriage, a lot of people who get separated say, well, we're living separate and apart. I don't have, $3,000 a year to take vacations, although we went skiing every year, we went to Hawaii every year. I'm not spending that money right now. And an attorney who tells you to fill out a financial affidavit, and you fill out a financial affidavit and you don't have the vacations on there, all of a sudden your financial need is a lot lower than what it was during your marriage, where your standard of living was much higher. So after you fill out a financial affidavit that's truthful, that has monthly expenses of $3,000 a month, when your actual living expenses during the marriage were $7,000 a month, there needs to be some accounting to put the court on notice and the other party on notice that, despite the fact that I'm spending this lower amount of money right now, this isn't my standard of living. So keep in mind that those are the things you need to address on the financial affidavit, a crucial document to your alimony claim. So prepare a schedule of what your standard of living expenses would be if you lived at the same standard you lived at while you were married to the other party. And include that as a separate page on your financial affidavit. And then be 100% truthful about what you're actually spending now, but footnote all those entries and say, this is what I'm spending now. But, a footnote to the $1,250 rental property could be that, this is a 1-bedroom, 1-bath property, and it's just a temporary housing until I, find some place where I live that's commensurate with, what I enjoyed during the marriage as a standard of living. From a person who's claiming alimony, of course, the higher your monthly expenses are, the more you can make a claim for alimony. Of course, everything has to be truthful, but I always encourage people to look at everything. A lot of people fill out this financial affidavit. Again, divorce is aggravating. Filling out a 10-page financial affidavit is aggravating, and it's not the thing you want to do. But if I can give you any advice of spending time on anything in particular, the financial affidavit is something you should spend a few hours on to make sure it's accurate. Make sure from an alimony standpoint, if you're claiming alimony, that you've included everything you can that you actually spend on that financial affidavit. A lot of people don't realize you get charged bank fees for everything these days. Banks charge you $15 a month for the account. They charge you for checks, and you buy the checks. They charge you for late fees. They charge you for ATM fees. All those things add up, and you may end up spending $40 or $50 a month just on bank fees. You pay for stamps to mail your bills. You pay for dry cleaning. Everything you can think of on that financial affidavit has a category where you can list it. So take a few minutes to look down at what you're actually spending and make sure you include everything on there. Regardless of the source of what the expense is, if you're spending that money, you should list it on the financial affidavit. And after you've filled it out, you need to sit down with your lawyer, go line by line through it with your lawyer, and make sure that you filled it out properly. Make sure that you understand what you've filled out, and make sure that everything is honest and accurate. And to the extent that you're claiming that you have a standard living expense that you're not actually paying now, like I said, put it on a schedule and attach it to the financial affidavit so you can make that claim for alimony consistent with the standard of living you enjoyed during the marriage. Now, from the other side of the coin, if you're defending against the claim for alimony, like I said before we started, the two things the court's going to look at determining whether to award alimony is one party's financial need for it and the other party's ability to pay it. So your ability to pay it is what's going to drive whether or not the court awards alimony to the other party. I've had tons of cases where there's been a financial need for alimony on one side, but a complete inability to pay on the other. And you need both of these things. It's a conjunctive requirement in order to get an award of alimony in the state of Florida. That court the other party has to actually prove that you have the ability to pay this alimony that they need. And filling out your financial affidavit is equally important to make sure that you do that properly. Again, fill it out properly. Include all the expenses you have, from bank fees to stamps to dry cleaning to gas to if you put on there, for instance, if you buy tires every year, figure out what you spend for tires and divide that by 12, put it down as a monthly expense. If you have oil changes every 2 months, figure out what you spend on an oil change, multiply by 6, divide by 12, and you put it down as a monthly expense. All these things add up, and if at the end of the day you make $3,000 a month, and after taxes you make $2,400, and you can demonstrate to the court that you're living at the bottom of the barrel as far as expenses are concerned, and that $2,400 doesn't go anywhere. At the end of the day, the other side has to prove that you have the ability to pay alimony to them, and if they can't do that, they're not going to get an award of alimony. So from defending an alimony claim perspective, make sure that you include every single item of expense that you have to make sure that your number, as far as your surplus at the end of the month, is as low as possible, being as truthful as possible, of course. Financial affidavit, we spoke weeks ago about making sure that that's an honest statement. Any competent attorney in a divorce proceeding, if you filled out a financial affidavit improperly, and I've seen this time after time in court and in deposition, will absolutely annihilate you if you've not filled out your financial affidavit properly. And it comes across very poorly when you filled out a financial affidavit and perhaps you had all intent of being honest. An effective trial counsel will make you look like a dishonest person and make you look like you lied on your financial affidavit to try and gain an advantage in the case. You don't want to go there. So make sure that everything on there is 100% accurate and honest, so that you don't run into a point where you're uncomfortable in trial or deposition when it looks like you've lied about something. The last thing you want to do in front of a judge is come across where you've lied about something. So make sure that that's filled out properly. And again, if you have a situation where you're out there and you've already filed a financial affidavit, or in a case you file a financial affidavit and you want to change something later, or some circumstance has changed, you always have the opportunity to file what's called an amended financial affidavit and change anything you need to change to make sure that that's accurate. So if you're out there and you did a financial affidavit and you're looking at it and you're saying, there's a mistake on this, I put the wrong amount, I maybe have put an annual amount in a monthly line, and you want to fix that, just do an amended financial affidavit, correct it, and you fix the problem. That way, if you go to court or to a deposition and you're asked questions about it, you could say, I realized that error and I fixed it by filing an amended financial affidavit. One thing I want to talk to you about is venue. And venue is a term that describes what county you file your action in. We talked a few weeks ago about jurisdiction for divorce cases, and venue is a different story. Venue determines whether you're going to file a case in Palm Beach County or Broward County or Miami-Dade County or whatever county in Florida you want to file it in. And venue is typically determined in divorce cases by the last place of residence where the husband and wife have resided together as husband and wife. So, for instance, if husband and wife resided together in Broward County and they separate and wife moves to Orlando, Orange County, and the wife cannot then file in Orlando and make the husband drive to Orlando to defend himself against a dissolution of marriage proceeding. The venue for the case, very simply, is properly brought in the county where the parties last resided together as husband and wife. So if you have a situation like that, don't waste your money filing in the county you just moved to, because the court's going to transfer venue back to the county where you resided as husband and wife together. And even if both parties have lived in Broward County as husband and wife and each moved to a different county, venue is still going to be in Broward County unless one of the parties agrees otherwise. So keep that in mind. Venue is an important thing, and I've seen people waste money trying to file in a county that was improper. You need to file in the right county. I want to talk for a moment about judges and conflicts. And from time to time, I've had this come up. You may get assigned a judge, and this is completely random, the filing of a divorce case or a paternity case, for that matter. The assignment of judges in the Tri-County area is completely random. There are multiple judges in all 3 counties that handle these types of cases, and it's complete luck of the draw which judge you get. However, when you get in front of a judge, and for instance, the judge may say, judges are required, if there's any potential appearance of impropriety or conflict, to disclose that to the parties involved. So I'm giving you a hypothetical here. If a judge comes out and says, well, I know this attorney on one side of the table, and I've socialized with this attorney. I went to this attorney's wedding, and discloses that to all the parties involved, because that's what judges are required to do if there is such an association between them. A lot of people it typically happens on the spot. It's typically something that is not known in advance of the hearing, and it typically happens at the first appearance when you go in front of the judge. So you have both parties showing up to court, both attorneys showing up to court. If you're pro se, of course, if you show up on your own. Judge will introduce themselves to everybody involved, and the judge may say, well, I know Bill Smith, he's an attorney on this case, and I've associated with him. I've had dinner at his house, or I've gone to his wedding, or because in all candor, judges are attorneys. The bar, even though it's in a big county, and the 3 different counties down here is large, there's still people who associate with one another. If that issue comes up, I typically err on the side of caution and will advise the client to allow the judge to recuse himself or herself from the case. A lot of people think a judge would take offense to that. I disagree with that. I don't think judges take offense when you do that. And I've had cases where clients have told me they didn't have a problem with it, and they just wanted to proceed, and then the case went a particular way and they weren't happy with it, and then they sort of look back on that with a feeling like maybe an edge was given to the other side because they knew each other. As confident as I am that doesn't happen, in order to avoid the issue, what I always recommend to people is if a judge feels compelled to disclose that to you, I typically would tell the client to have the judge recuse himself or herself and get a different judge assigned to the case. It just avoids the issue entirely. And again, don't feel like the judge is going to have any hard feelings about that. Judges have hundreds of cases, if not thousands, and they don't mind giving up cases from time to time to a different division. So if that happens and that conflict presents itself, ask the judge to recuse himself or herself. I want to talk about wills and tax refunds, 2 different issues that come up. These are both interim issues in divorce cases, because obviously you have divorce cases that could span, half a year. It could span a year, 2 years, even unfortunately more than 2 years. Some cases go on. And a lot of people have situations where they may have an illness that is terminal. They may have situations where, they don't know what's going to happen, how long litigation is going to take. If you have a will, and this happens a lot, people who have been married for a long time typically, will have wills naming each other as the primary beneficiary, naming children as secondary beneficiaries, and so on. If you have a will and you're in a divorce proceeding, and as in most cases, you probably don't like the other person all that much, otherwise you wouldn't be getting divorced. Think about and consider having an interim will prepared. And the reason I say that is that if you have a will and something should happen to you, you have an accident and you die, or a heart attack and you die, anything should happen to you and you die, that will, regardless of the fact that you're still in divorce proceedings, will be effective, and your spouse is going to get everything you have. And what you need to do is prepare a will that, if you wanted to do this, that disinherits your spouse to the full extent of the law, to the full extent that's possible. And you may also have a situation where neither of you has a will, or one of you has a will. And in that case, if neither of you has a will and you're married in the state of Florida and you're going through a divorce proceeding and one of you dies, the other spouse, the divorce proceeding is nullified. It's dismissed because of the death of one party. And everything you own, everything you had, goes to the other party. So I always encourage people going through a divorce proceeding, if it looks like it's going to be protracted, it's going to go on for a long period of time, to prepare a very simple interim will. And that will disinherits the other spouse to the highest extent permitted by law, to the greatest extent permitted by law. And it's very simple. You do a 2 or 3 page will and you name the people you want to name as your beneficiaries. If you have children, and you want to name your children as beneficiaries, you name your children as your primary beneficiaries, and your sister or friend, whoever you want to name, as your personal representative, and you disinherit the other spouse. Now in Florida, they have something called an elective share, and I want to explain what an elective share is, because a lot of people think, well, if I disinherit my spouse, they're not going to get anything, and that's not true. If you disinherit your spouse with a will, you're disinheriting them to the greatest extent permitted by law. And what that does is it disinherits them as a matter of fact, and then they would have to make what's called an elective share if they wanted to. If they don't do that, they don't get anything. But what they can do is make an elective share. And what an elective share is they can come in and say, I'm the current spouse of this decedent, and I want my 1/3 elective share of their estate. And what they're going to get is 1/3 of your assets. Well, it's the best you can do in the situation. It protects you with 2/3 of your assets, so that not 100% would go to the other spouse. But it's certainly something you want to do, particularly in a divorce where the other party you're in a contentious case. You're fighting about everything. They're trying to get everything you have, and you're fighting with them. And unfortunately, I've had 2 situations in 18 years where parties to a divorce had died during the proceedings. Fortunately, in one situation, I had encouraged the client to obtain an interim will, and he did. But in the other situation, they had not followed my advice, and the other spouse ended up getting everything they had. But it's certainly something to think about. It's certainly something I encourage you to do, particularly with a case that's going on for a long time. And it doesn't take much time to do it. There are a lot of programs where you can prepare your own wills online. Although, again, I don't encourage you to do that if your financial means don't allow you to have an attorney prepare a will. Do whatever you can to protect yourself in that regard. Wills are not expensive to prepare. I prepare wills for people, and typically the entire will package, including designation of healthcare surrogate, living will, and powers of attorney, and the will itself, you're looking at about $600 to prepare it. It could allow you to leave a lot more to the people you want to leave it to if something should happen to you in a divorce proceeding. And that will, if you have one done that disinherits your spouse to the greatest extent permitted by law, is a will that you can keep, which is an interim will, is a will you can keep even after the divorce proceedings are done, because after you're divorced, again, you're disinheriting that spouse to the greatest extent permitted by law. After the divorce goes final, they get nothing. That elective share that they had while they were married to you is gone. It's gone, so they can't get that. So it's a will that you can invest in, one that you can keep even after the divorce proceedings are done. So it's well worth the investment and something you should consider doing. I want to talk about tax refunds. And a lot of people going through a divorce, this is sort of an afterthought, the tax refunds that come during a year. As you know, during a marriage, a tax refund is typically the thing that you look forward to every year that comes in. It's typically thousands of dollars in money that you expect to come in each year. And when parties get divorced, you may have one spouse who, instead of waiting for the other spouse to file, and I've seen this happen an awful lot, particularly when there are children involved, we'll have a situation where one spouse goes and files immediately and claims all the children for tax purposes and gets a huge refund. And then, I have somebody who comes in and asks me, well, are they allowed to do that? Is that fair? Can they do that? And legally, can they file and do that? Yes. But it's certainly something you want to bring up during the divorce proceedings. That's not something you should just write off and forget about. And what you need to do in a trial proceeding or in a temporary needs hearing is to try and get your hands on half of that money that came in, because had you filed jointly and both of you claimed all the children together, or even if you don't have children, you filed jointly and had a huge refund, that's a marital asset you both should split. And unfortunately, what happens in those situations is one spouse claims all the children, files quickly, gets a huge refund check, and the other spouse is left not being able to claim anything and may owe money. And it's not fair to that spouse to have to do that. So what I encourage people to do in preparing for a trial in that type of situation is to have testimony prepared, or have an accountant show up that would have prepared a hypothetical tax return that has the parties filing jointly, to be able to testify to the court that had they filed jointly, there would have been an $8,000 refund and they each would have shared $4,000 of that. But in this situation, the one spouse ended up getting, the full amount of the refund, or 90% of the refund, and the other spouse didn't get to share in that, so that you can get an equalization payment on that tax refund. So those things, typically an afterthought from an asset distribution standpoint, but certainly is a lot of money, and not something you should throw away. Recognize that is an issue going into your divorce proceeding, and make sure that your attorney asks about that issue in your divorce case. Also, in the same vein, if you have a life insurance policy that has a cash value to it, a lot of people don't think about those issues. That is an asset to the marriage as well, presuming that the policy was purchased during the marriage and that it was contributed during the marriage. So keep that in mind as well. I've enjoyed spending the hour with you. This is Sean Shepard. I encourage you to call me at 954-632-0668. That's my line. If you have any questions at all, I'm here. I offer free consultations in any area of family law that you should need. Enjoyed spending the hour with you this week, and I look forward to spending another hour with you next week at 5 o'clock on Friday. Have a great weekend. Go USA on Sunday. I'll see you next week.
Thanks for tuning in today to the South Florida Family Law Show with attorney Sean Shepard, with offices in Fort Lauderdale. If you would like to set up an appointment with attorney Sean Shepard, call his offices at 954-632-0668. And tune in again next week for another South Florida Family Law Show with attorney Sean Shepard. And let Sean answer your family law questions. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of the station, its staff, management, or sponsors.